Today, I've been asked to talk a little bit about any separation of powers questions that might arise in looking at regulation of procedure with the Supreme Court. Congress obviously has a very important constitutional role to play related to the federal judiciary. Congress is responsible, obviously, for establishing inferior federal tribunals, and since the Judiciary Act of 1789 has taken significant action to regulate and address the procedure and subject matter jurisdiction of federal courts, including the Supreme Court. But Congress's power in this area with the federal judiciary is pegged to its authority to establish inferior tribunals and also its necessary and proper power to enact laws to carry into execution the vesting of federal judicial power in the Supreme Court and other federal tribunals. And so it's not an unbounded authority necessarily to regulate all actions of various judges and justices. And since 1789, this body has had a practice of leaving the courts with significant discretion in regulating procedure and also administration of their own affairs. Two additional principles in the constitutional structure that I think are relevant to the discussion today include the concept of the Supreme Court sitting over inferior tribunals, the concept of a hierarchical system within Article 3, and then also the more constrained role of the judiciary to resolve discrete cases and controversies, in contrast to this body and the executive, which are elected by the American people. And so I think those principles come up and touch on several aspects of the draft legislation. First, the legislation has some provisions in it providing for notice and comment procedures when the Supreme Court looks at its own procedural mechanisms and recusal rules and ethical codes. And so in contrast to this body and the executive branch, where the public, through the electoral process and commenting, has a much more direct role in procedures, the Supreme Court and the federal judiciary, by the terms of the Constitution and the constitutional structure, were set aside to be impartial, as the title of this hearing reflects, and judges given tenure protection and salary protection so that they would not be too swayed by the public. And so I think it's important to think through whether there is tension between having the public comment on ethical codes of the Supreme Court, which we want to stand apart from political considerations and mores. In addition, aspects of the draft bill enable individual members of the public, even apparently in situations where they don't necessarily have a case before the Supreme Court, to raise individual ethics complaints and try to initiate investigation into various aspects of judicial or Supreme Court affairs or recusal decisions that also may create tension with the notion of an impartial judiciary that's set aside from the political process. And then finally, aspects of the bill that give lower court judges a role in overseeing or approving of various justices' decisions, whether to recuse or how to handle their role in a particular case, also may sit in tension with the constitutional structure. As a policy matter, too, I think it's good to think about whether it makes sense at this point to significantly increase regulation of the judiciary, which by many metrics I would argue is actually working quite well. President Biden, at the start of his administration, established a commission to review and look at the Supreme Court and courts in general and its structure and how it's operating, and that commission did not coalesce around a single significant change that needs to be made. Close to 40%, more than 35% of decisions or judgments each year over the past 10 years issued by the Supreme Court are unanimous, and Congress has many tools at its disposal to regulate practice of courts through subject matter jurisdiction and other procedures that have a much more long-standing historical provenance than some of the disclosure and recusal provisions in this particular bill. Thank you. I look forward to discussing this further and answering questions.
I think you